Hello and welcome to Polity Matters. My name is Ben Ratliff, and you are joining us in the middle of an episode on BCO Chapter 32. We recorded the first half of it last week, and we're giving you the rest of it today. It's not quite half, though. We made it through BCO 32.6 last time, and we're jumping in to BCO 32.7 through BCO 32, that's right, BCO 32.20. So get out your books. Come listen in as Fred and me and the guys work through the rest of this chapter. 32.7. The time which must elapse between the serving of the first citation on the accused person and the meeting of the court at which he is to appear shall be at least 10 days. The time allotted for his appearance on the subsequent citation shall be left to the discretion of the court, provided that it be quite sufficient for seasonable and convenient compliance with the citation. So, back up in 32.3, you cite him to appear. It says up there as well that he's got 10 days at least. But if you have to cite him a second time to appear, it's up to the court's discretion. Am I reading that right, Fred? That they can give him a few days if that seems best, or many days depending on how they see it to be necessary.
Yeah, I think what's important here again is you don't want to short circuit someone's rights. You can't say, oh, well, 9 days is enough. However, you don't need to say to the accused, we're going to have, the next meeting of the court 14 days from now. And he says, well, yeah, that's good, but, I got a racquetball tournament, so I can't make that date. The court needs to use some discretion. If the guy says, well, I'm going to be out of the country, then I would say that a court would be wise to pick another date. Yeah. Because if the court doesn't pick another date, the guy's not going to show up. They're not going to be able to proceed with the trial. They might need to find him contumacious. The guy would probably complain and say, I'm not really contumacious. I was just out of the country. I couldn't physically be there. I'm more than willing to sit for a trial. And so you don't want to make yourself more work. So, I think this is sort of the back and forth that a court needs to do. It doesn't need to bend over backwards for the accused, but it can't be hard-edged and unreasonable. It needs to be, in that sense, pastoral and to follow along with the spirit of gentleness. It needs to give the accused an opportunity to actually be a part of the process.
Yeah, and this gets back up to where we were talking about before about trying to make it as fair as possible, like offering advice and making sure that they know the rules. We want to make sure the whole process is fair when we're going through that process, and that includes timetables. And so while the BCO specifies the minimum, it doesn't give a maximum for when you should schedule these things. And it's probably somewhat prudent to give more time than less time for that exact reason, that you cite someone, a month in advance, and then they say, hey, I can't do that. Oh, well, then you can get that all figured out with a much longer runway than a shorter one. And so being fair, not being overly scrupulous over this kind of stuff is probably for the best for your sake, to help you sleep at night, but also to have a fair trial.
Jared, you're still with us, right? Just want to, everybody who's listening is wondering.
I'm just taking notes and learning.
You're just there. Good. Good. We'll keep going on to 32.8. When the offense with which an accused person stands charged took place at a distance, and it is inconvenient for the witnesses to appear before the court having jurisdiction, that court may either A, appoint a commission of its body, or B, request the coordinate court contiguous to the place where the facts occurred to take the testimony for it, or C, have the testimony taken by video conference, which shall employ technical means that ensure that all persons participating in the meeting can see and hear each other at the same time, and which allows for live cross-examination by both parties. The accused shall always have reasonable notice of the time and place of the meeting of this commission or coordinate court. I apologize for my stumbling. I was not prepared for a couple of those words.
Ben, here's where I get to say that I authored this provision.
Yes. I can blame you for my word trip.
C is a Grecoism. And, it came out of an instance where someone said to me, we have a trial and we have a witness, and the witness says they don't want to get on a plane and fly to another city to give 15 minutes worth of testimony. And I said, that sounds reasonable, but yet it would be good if they could give their testimony. And you don't want to have the commission fly to the guy under A. You don't want to have a different court take the matter up because one guy's in a different spot. So how can you do this? So we added C. And that's because when 32.8 was originally written, Zoom didn't exist. GoToMeeting didn't exist. And so now, as long as there is the ability for cross-examination, et cetera, this kind of way of taking evidence is available to a court.
Doesn't this also help with the problem of if the issue involved had been some sort of abuse or something that was traumatic to somebody, that they don't need to be in the same room, we can still hear the testimony and the person doesn't actually need to be in the same room as somebody else and open up all of those wounds.
That's right, Jared. So I wrote this provision and it was adopted, I don't know, maybe 7 or 8 years ago. And then 35.3, which you guys will talk about again in the future, when we were going through exactly these issues that Jared's talking about, it took off on 32.8 and put a lot more specificity. So 35.3 is much more specific and is very helpful. This 32.8 is just a very general provision, but that's exactly one practical outworking of this principle.
Let's talk about B for just a second. A coordinate court contiguous to the place where the facts occurred to take the testimony for it. For somebody else, definitely not for me, for somebody else that needs to know what this means. I like to try to play the role of ignorant listener and then just ask questions based on that assumption. So,
sure. So let's take an example of a minister. Let's say that a minister is accused, as a charge is brought against a minister. He was a pastor in Atlanta, and 6 months later, he moves to Mississippi, and he's charged with something, and all the witnesses are in Atlanta, and there's no context with Mississippi except that's where the accused is located and would be the court of jurisdiction. And so the court in Mississippi could request that a court in Atlanta take the testimony, bring the witnesses to them, and then transmit that to the court in Mississippi. Probably, either by written transcript or more likely now in our day and age by video. And so probably the instance in which this B would probably not be used very often now because you could use, individual video conferences. But in the example I gave, you might have 20 witnesses in Atlanta and there's no reason to zoom them all into Mississippi. You would just have the court in Atlanta hear all those witnesses and then send those proceedings over to Mississippi.
Does coordinate mean that if it's a session hearing the trial in the original, that it needs to be a session somewhere else doing it? Is that That's
how I would take it. Yes, yeah, okay. It would be the same level, presbytery to presbytery, session to session.
All right, y'all good? Jared? I'm just going to keep checking with you every single time. Okay, this is great. Let's keep going. That was 32.8. 32.9. When an offense alleged to have been committed at a distance is not likely otherwise to become known to the court having jurisdiction, it shall be the duty of the court within whose bounds the facts occurred, after satisfying itself that there is probable ground for accusation, to send notice to the court having jurisdiction, which shall at once proceed against the accused, or the whole case may be remitted for trial to the coordinate court within whose bounds the offense is alleged to have been committed. So still dealing with distance, right, from the previous paragraph, but but jumping back a little bit to how accusations and charges and indictments come about.
Right. So this is more than just testimony. This is, if the court of jurisdiction wants another court to deal with the whole matter, they can send notice and ask for that. So, again, in my example, if a Presbyterian in Atlanta had heard about this, they could ask the court, rather than take up the charge themselves, they could ask the court in Mississippi to proceed.
Some of these are a lot clearer than you think they're going to be. 3210. This one's just for Scott and his stack of green paper. Before proceeding to trial, courts ought to ascertain that their citations have been duly served.
Yes.
Do you have this tattooed on your body somewhere, Scott?
Yes, I do. Make sure that you use the bougie certified mail receipts. You should see them send these things out. There's like 10 to 15 stickers all over them just to get them out.
Are they like stamps? Like, can you collect them? Different versions, different
Maybe like they're stamps for trauma or something, but not physical stamps.
This set, the printer that made these, it was running out of green ink when they printed them, and so it's a little fainter than the other ones are. Okay, sorry. Cool. 3211. In every process, if deemed expedient, there may be a committee appointed, which shall be called the Judicial Committee, and whose duty it shall be to digest and arrange all the papers, and to prescribe under the direction of the court the whole order of the proceedings. The members of this committee shall be entitled, notwithstanding their performance of this duty, to sit and vote in the case as members of the court. Fred, help us understand. Yeah.
All that really you need to understand with this is the difference between a committee and a commission. So this committee is not deciding the case. It's not sitting in judgment. It's not pronouncing guilty or not guilty. They're just helping to pull things together for the trial. And then, of course, that last part of this section makes it clear that by so doing, they're not making a statement about guilt or innocence. They're not forbidden from actually sitting in judgment. They're just gathering and organizing.
So, like, this would be a committee that could send citations and make sure that they're received and gather paper evidence, different things. Is that kind of what you're talking about?
Yeah, I mean, if you had, for instance, a very large set of documentary evidence, let's say you had 100 documents or 150 documents, they would take them, they would organize them, they would number them, they would put them in a table of contents, they might label them so that, we know this is letter from Bob to Harry, etc. But again, it doesn't have anything to do with proving the case. It's just gathering up the materials.
(3212) When the trial is about to begin, it shall be the duty of the moderator solemnly to announce from the chair that the court is about to pass to the consideration of the case, and to enjoin on the members to recollect and regard their high character as judges of a court of Jesus Christ, and the solemn duty in which they are about to engage. So to some degree, hearkening back up to 32:1 and bringing, reminding us about the significance of these proceedings and the process we're in. Are there particular words that have to be used, or the moderator can use his discretion in deciding how to communicate these things?
No, I don't think so. I mean, this sounds, pretty pedantic, but what I would do in this instance is I would just repeat the language of 3212.
Yeah.
I remind you of, your solemn duty and enjoin on you, to recollect and regard your high character, and to, only consider matters in accordance with, the scriptures, the truth, and our book of church order, or something like that. I think this is just a reminder. These sorts of things are here to remind us that when we're in process, it's formal. There is a sense in the greater church that the informal is more spiritual than the formal. Mm-hmm. And that is not true. You can handle things flippantly with formality, and you can handle things flippantly with informality. And I think in instances like this with discipline, when you're talking about the soul of sinners, the purity of the church, and the glory of God, it is a very good thing to remind us that this is a formal process and we should take it seriously.
Yeah, isn't there a lesson in Christ's trial before the Sanhedrin that they're throwing away of their procedures? was part of the great outrage of that section of Scripture when you're looking through there, that they would strike the accused, that they would tamper with witnesses. I remember hearing once David Coffin defend something that the SJC had done, and he said, "I think Jesus is pleased when we follow our rules." And at first I thought that was kind of outrageous because people were debating, the merits of something. And then later on I thought, yeah, actually he's right. He's right.
Yeah.
Glad you're here, Jared. 32:13. In order that the trial may be fair and impartial, the witnesses shall be examined in the presence of the accused, or at least after he shall have received due citation to attend. Witnesses may be cross-examined by both parties, and any questions asked must be pertinent to the issue. Okay, so Fred, my question that comes in here is they should be examined in the presence of the accused, or at least after he has been notified or has received citation to attend. I thought we couldn't try a guy if he wasn't there. So how is this working? Does my question make sense? Okay.
Yeah, I think this is dealing with an odd instance in which, for example, you might have a multi-day trial, and he didn't attend for that witness. I think the other thing is, this is tempered by the language of 35:3, which is not quite in the presence of the accused, but he would be given a citation, and he would be, typically speaking, the way you deal with that in like an abuse case would be the accused would be able to hear and see the testimony of the witness, but the witness would not see the accused under 35:3b. And so he would have received a citation to attend, but the witness would not be in his presence. The witness wouldn't be, for lack of a better phrase, intimidated. So this is a pretty rare instance, I think.
Okay. And cross-examination, it would work a lot of the ways that we see it work on TV, for lack of a better connection, so that what the prosecutor examines his witness first, then the defense or the accused, his representation, and then it goes back to the original again for a cross-examination.
Correct.
Or for what do they call it? Cross is
Redirect.
The second time. Yeah, thank
Redirect.
you. Redirect, yeah. So that should feel familiar to most folks. All right, 32:14. On all questions arising in the progress of a trial, the discussion shall first be between the parties, and when they have been heard, they may be required to withdraw from the court until the members deliberate upon and decide the point. Fred, can you explain this? Because it seems clear, but then I start to wonder after some of the experiences I've had. Yeah, what's questions arising in the progress?
So this, again, deals with our lack of specificity, but it is in the vein of what you would normally understand in a trial. Just because it doesn't say in our book, one of the parties may object to witness or to a testimony or something, doesn't mean they can't. So they can object. And if then the parties would come to the court and say, this is why you should let this witness testify or why you shouldn't. And then the court has the opportunity to, withdraw and to consider the point. So here would be one instance. Let's say that you have someone who's listed as a witness, but they can't be at the trial. And the prosecution may, for example, want to submit a written document summarizing their testimony. The defense might object to that. And then the court would have to decide whether to admit that or not. And then it would make a decision and deliberate on it and decide. This is, again, it's just another instance. I'll be a broken record. If you can get the parties to agree on certain parameters, then you foreclose an avenue of potential ecclesiastical litigation. Because remember, unlike our court, if someone, like our courts, our civil magistrates, if someone's found guilty, they may appeal. If someone is found not guilty, the prosecution can complain. So either side that loses can further the litigation. So anytime you can get both parties to agree, you foreclose that avenue, and I think helped the church.
All right. 3215. When a court of first resort proceeds to the trial of a case, the following order shall be observed. 1. The moderator shall charge the court. 2. The indictment shall be read and the answer of the accused heard. 3. The witnesses for the prosecutor and then those for the accused shall be examined. 4. The parties shall be heard. First the prosecutor and then the accused, and the prosecutor shall close. 5. The roll shall be called, and the members may express their opinion in the case. 6. The vote shall be taken, the verdict announced, and judgment entered on the records. So this is basically an outline for a trial.
Yes.
That's all it is. Yeah. We've seen number 1 already back earlier with charging the court ahead of time, and this is the way it goes. I mean, I don't know, Fred. What do you want to pull out of this and observe for listeners? It's pretty straightforward for the most part.
Yeah, I just, again, think it's one of those things you follow the playbook. So the court shouldn't say, you know what, we want the accused witnesses to go first.
Sure.
There's just no reason to do that. The only thing that I can say that I think, is proper under this provision is that after the parties have been heard, the roll can be called and the trial can be suspended so that the judges have an opportunity to discuss. I don't think they need to 30 seconds later say guilty or not guilty. I think they can discuss, and then especially in some instances, you won't just have a guilty, not guilty. You'll have a written decision, and with reasoning as to why your finding is this. Especially if you think there might be appellate litigation, and so I don't think this should be read as it has to all be done in the next 5 minutes.
I think number 5 on here can surprise some guys. The roll shall be called. Members may express their opinion in the case. What that just means that everybody in sitting as a judge has a chance, if they want to express what the direction they're leaning, what their thoughts are on the case, whatever it may be.
Yes.
Before they have to take an actual vote. So you don't have to proceed immediately to vote. You can discuss among them.
That's correct. And I think 5 can occur outside of the context of open court.
That's what you were saying. Okay, I understand. So they could send everybody. Yeah.
The judges could in open court say, I'm thinking this guy's really guilty. They could. Mm-hmm. But I would rather that you do it not in open court and then you come up with a verdict.
Okay. Anything else there? Jared, you leaned forward. I thought maybe you were. You're still there.
It's
You're
basically
still there. Okay.
a jury deliberation. So you get to deliberate as a jury here.
Yeah. Okay.
This is still very general. There could be a lot more structure that one can add to this in order to make it perhaps a little smoother. It just doesn't go into all the details of cross-examination, allowing judges to ask their own questions. There's a lot that could be added. And so this is just the bare minimum. And you might want to add a little more assurances as you're working through what that actual day of court will look like. It could be long, it might be short, but having a good structure or a good template will help you stay on task instead of getting off topic.
Speaking of staying on task, 3216, either party may, for cause, challenge the right of any member to sit in the trial of the case, which question shall be decided by the other members of the court. So if one of the parties doesn't want you to be a judge, the other members of the court vote whether or not you get to be a judge. Is that basically the way it happens? You don't get to vote for yourself or against yourself.
Right. Yes.
That's especially good if you have like a very small session. Where it's just like there's 3 of you. Wait, I don't think you should be on there. Well, I vote for me to be on.
Yeah. Here, just for the sake of example, so this is made especially clear, what would be a circumstance in which a party may not want an individual to serve as a judge, though they're a member of the court? Is there a helpful illustration?
The most obvious would be if such judge were a key prosecution witness.
Okay. So you would be saying that being a key prosecution witness wouldn't necessarily remove him from sitting as a judge, but one of the parties, probably the accused, could challenge his right to sit as a judge in the case because he had been so much on the side of prosecution.
So you can't have the language be just if they're a witness, right?
Right.
Because if that were the case, then the accused would call every member of the court as a witness and say, "Sir, am I a member of our church?" Yeah. Okay, you've given testimony. You're recused.
Yeah.
Right? But if someone is, a substantive witness, I think we would also say, if they're testifying to the guilt of the accused, they probably shouldn't be a judge sitting in the case.
Yeah, you think of that too if, say, one of the elders, one of their children was the accuser or the accused. Obviously, close relationships like that may mean that you can't be impartial. And probably at that point, you need to just recuse yourself rather than having them have to vote you out.
Mm-hmm. Okay. 3217. Pending the trial of a case, any member of the court who shall express his opinion of its merits to either party or to any person not a member of the court, or who shall absent himself from any sitting without the permission of the court or satisfactory reasons rendered, shall be thereby disqualified from taking part in the subsequent proceedings. So there's two things happening here. Fred, you want to hit that first one for us at least? The expressing of an opinion?
Yeah, you can't be expressing, opinions. And this is why whenever someone talks to me about something that's going on ecclesiastically, my statement is, okay, first, I'm a member of the SJC. Second, you don't want me recused. So stop. Don't tell me anything more. Because if I express any kind of opinion, it's also one of the reasons, this is what's really healthy. It's one of the reasons I don't leap into any of our big controversies on social media. Because I don't want to have an opinion that comes back to me. Now, I will say this. This is expressing an opinion as to the merits of a case. It's not expressing an opinion about a theological issue or, an interpretation of our Constitution or of an overture or something like that. It has to deal very specifically with the merits, of the party.
This is why when I text or call Fred with questions about things, I only ask him very generic questions, and I let him ask for more if it's necessary or if even, in certain circumstances.
That's right.
Yeah, so if you're calling guys that are on the SJC for advice, listeners, let them invite more if they need it. Don't put them in a position to have to do here, which is disqualified. What's the other one? So somebody, a member of the court, has absented himself from sitting without the permission of the court. So he's been outside of some aspect of the proceeding, and he didn't get permission to be gone, and so he may have to be disqualified.
Again, this might be a multi-day trial, and someone can be present on Tuesday and Wednesday, but not on Thursday. And so he'd have to get permission, and typically that would be something like I'll listen to the recording of that witness, or I'll read those documents that are going to be put into evidence or something like that. But you need to let the court know in advance, and the reason you need to let the court know in advance is the court may say, if you're absent, this is a really significant witness, we don't think you should vote.
Yeah, good. Okay, 3218, we're going to talk about Scott for a minute. Minutes of the trial shall be kept by the clerk, which shall exhibit the charges, the answer, record of the testimony as defined by BCO 35.9, and all such acts, orders, and decisions of the court relating to the case as either party may desire, and also the judgment. The clerk shall without delay assemble the record of the case, which shall consist of the charges, the answer, the citations, and returns thereto, and the minutes herein required to be kept. The parties shall be allowed copies of the record of the case at their own expense if they demand them. When a case is removed by appeal or complaint, the lower court shall transmit the record thus prepared to the higher court with the addition of the notice of appeal or complaint, and the reasons therefor, if any, shall have been filed. Nothing which is not contained in this record shall be taken into consideration by the higher court. On the final decision of a case in a higher court, the judgment shall be sent down to the court in which the case originated. I feel like there's a lot happening in here. A lot of things being said. Scott, have you had to do something like this? I can ask you that without you giving anything up, right? Have you had to accumulate stuff from trials?
No, not as a clerk.
Not yet.
But you're basically just the administrator, right? That's what it's telling you to do, is that you're in charge of the church, the presbyteries, in the presbytery context, the presbyteries minutes, you're also in charge of maintaining and stewarding all the records and minutes for the trial itself. And so you get an additional duty as a clerk when you're proceeding to trial. You're the one that is the caretaker of all of the records and making sure that they are filed in an accessible manner, not only for the record for your own church to maintain, but for the case of appeals, but also for the parties involved.
And so if you appeal or complain, raising the issue to the next higher court, that clerk as well begins to start participating. So what I think about here is that when you appeal or complain up to the SJC from a presbytery issue, you actually are going to email the stated clerk of the PCA. It feels big. It almost feels disconnected from the SJC, but then you remember the SJC is the commission of the whole GA.
And I think the key here is when there's appellate ecclesiastical litigation, a complaint or an appeal, it is not a rehearing of the matter.
Yeah.
You don't take testimony again. You don't have new evidence. You just review the evidence that the lower court considered. That's the record of the case.
Yep. Yeah, sometimes there's this idea that if I appeal it, that we'll be able to re-adjudicate it. And we're just going through the records that have been compiled and asking for more clarification. And,
exactly.
And so it's a much more streamlined process, much shorter, not as in-depth as perhaps a whole trial.
Right. That's correct.
Listeners, if you really want some good deep reading, you can go to the operating manual for the SJC. I don't know, the articles or sections, I forget. Anyway, Chapter 7, Chapter 8, Chapter 9, you get into some things like this. The record of the case is defined in Chapter 7. Anyway, really good late-night reading, I guess, if you need it.
Or tune in 2027 when we just start going through that.
We go through the SJC manual. Okay, I think we're on the last page. 3219. No professional counsel shall be permitted as such to appear and plead in cases of process in any court. But an accused person may, if he desires it, be represented before the session by any communing member of the same particular church or before any other court by any member of that court. A member of the court so employed shall not be allowed to sit in judgment in the case. Fred, you probably want to dive into this one because are you bringing something for this, or is it somebody else that's bringing something for this, or that we have in front of us now? I can't recall.
Just trying to think, isn't this one of the, let's ask our amendment tracker, isn't this one of our issues for that are being approved by presbyteries?
That's
so
right.
This language is very likely going to change after next assembly because it's, according to our brand spanking new PCA Administrative Committee dashboard, it is received 52 presbyteries in favor and needs 58. So before assembly. And what this means is this. So you can't hire a lawyer and pay him to represent you in an ecclesiastical case.
Even if he's a PCA member?
If there is a PCA member or elder who fits the requirement here, who is a lawyer, he can represent you or assist you, but he can't do it for remuneration. That's what has been, determined, at least by the SJC, and I think it's kind of been iterated out through the PCA, and that has some consternation, from people, but that's clearly where we are, right now. The amendment, if I recall, broadens this somewhat to allow not just you to be represented before a session by a member of the same church, but by a member of the same church or by a pastor, a teaching elder in your presbytery, and perhaps even by a member of a church in your presbytery, so it's expanded. But it's not by anyone in the PCA. Originally, when this came to the Overtures Committee last year, it was to let anyone in the PCA represent anyone in any case. And that was whittled down. So I didn't write this amendment, but I did write an amendment to the amendment that's going to come, whittling it down to kind of being a halfway house. So we couldn't have, a professional series of ecclesiastical litigators, but yet at the same time realizing it might be really hard in a small church to find another member of your church who knows enough about the book to help you. Yeah. And so, this comes all the way back. I would say this comes all the way back to the beginning of 32. A court should advise anyone who's accused of this provision specifically, that you're not on your own, that if you need someone to help you understand this, you should go find someone. I would even go further. Courts would be wise to say to an accused, here's a list of guys that you could go talk to. So, if someone comes to me and says, Fred, I've got this case that I think might come to the SJC, I say, whoa, wait a minute here. But let me tell you who you could talk to. There's a half dozen guys who used to be on the SJC and who have retired or moved on. They know all about this stuff, but they're not going to be recused, and they could represent you. Call them. And I think it's helpful to give people a list of names, not just to let the accused wander around. Because, again, you want as clean of a process as you can get so that justice is served.
Yeah, so as simply as possible, the person who represents you could be a lawyer. You just can't pay them as a lawyer, is what that provision is saying.
Yes, correct.
Sorry. Okay. I think we're finishing it up. 3220.
Mm-hmm.
Have we said that before? Have we ever had a section 20 before, Scott?
No.
I think my plan right now is to release this as one very, very long episode, but we'll see what happens.
Hour and a half.
The accused or a member of the court may object to the consideration of a charge. For example, if he thinks the passage of time since the alleged offense makes fair adjudication unachievable. The court shall consider factors such as the gravity of the alleged offense, as well as what degradations of evidence and memory may have occurred in the intervening period. Why is this here at the end, out of curiosity? Is it just because there was nowhere else to stick it when it was added, and so we put it here?
I don't know. I mean, a version of this predates me.
Okay.
I can say that this was recently amended in the last 3 years, maybe 4 years, and I'm not guilty of that. There's a certain ruling elder in the Pacific Northwest that's guilty of that. It's kind of Howie Downhill is kind of my partner in crime at amending the book, and you're going to see us both in force in the overtures this year. But anyway, this is a change because there was a provision that people sort of thought was a statute of limitations, but it really actually wasn't a statute of limitations. It was kind of odd. It was actually a spur to courts to bring a case of notoriety quickly, but it wasn't a strict statute of limitations. And so that was changed here to give what's essentially a statute of limitations that is not black letter, not a black line. So if something has been, many, many years ago, a court a party can say, look, this guy charged me, with lying 16 years ago. Like, I can't remember anything I did 16 years ago. And I don't know how the people that I was supposed to have lied to are dead. And, how are we supposed to adjudicate this? And so he could appeal to the court, and the court can say, yeah, you know what, you're right. That's a little too long. But there's no magic number here. So a guy could make the same argument in 18 months. Is it going to prevail? Probably not as likely. But again, there's no black letter law here on that.
You just titled the episode, by the way. The people I lied to are dead. Okay.
Part 3. This is part 3 of the episode.
Part 3. Anything that we want to say in conclusion? I was going to mention at some point, I'll say it here. Jared and Fred both alluded to it early on at the top of the episode, that 32 is, it does a lot of what 32.3 tells us to do in assisting parties in understanding the rules of discipline. So if you're trying to understand the process, 32 is the place to go to begin with, at least. And we don't have a Bill of Rights, so to speak. Jared, what have we talked? We've talked about doing something like that before. Mm-hmm. we don't have something like that properly, but 32 is as close as we're going to get. And so this is where you want to go start and then let it move you to other portions of the book to understand the process better. You guys, anything else y'all want to add as we conclude this relatively significant chapter of our Book of Church Order? Okay.
No, thank you very much, Fred. That was
man, that was great.
Yeah, I loved mostly listening this episode and learning a lot.
All right, let me close this down. As either party in a case of process would certainly say, this podcast is over. Thanks for joining us. Be sure to tune in next week when Steve Dowling returns to discuss BCO 33, special rules pertaining to process before sessions. If you're interested in learning more about what we've talked about, you can check out the show notes, so there won't be much there except a link to the BCO. You can find those in your podcast player or at politymatters.org. Do follow us on social medias, subscribe in your podcast app of choice. Again, we already said it, but our great thanks to our friend Fred Greco for joining us today. We hope that he'll come back and join us again in the future. And I think he is. I think we have him on the schedule for more in the ROD, so he'll be back. If you have questions or comments, reach out to us. You know how to do that. There's links down in the show notes. And you can click a link down there to support our work as well, which might get you a button with an ice cream cone on it that says Polity Matters. Who knows? Anything can happen these days. Thanks again for spending time with us. Until next time, say goodbye, gentlemen.
Goodbye.
Goodbye.
Bye.
Y'all take care.